Hello, good night. This is U.S. Immigration Attorney Sharifa Tharpe. I am here live to take your U.S. immigration related questions. I am also here to give you a great topic tonight. And tonight, I am going to ask you the question: did you get a notice of intent to deny in your green card application? And the reason I'm asking that question is because the notice of intent to deny, it could be a possibility if there is a situation in your case where the immigration officer has reviewed your application, and there is something that they feel is making you ineligible for status in the United States. If that is the case, then the notice of intent to deny will be issued. If they are convinced that they're going to go ahead and deny your application, unless you can prove that you can prove otherwise. So if you've gotten a notice of intent to deny, it's not a denial yet. And it is your last chance to prove that you indeed are eligible for the immigration benefit. So if you read the notice of intent to deny closely, you will see that they give you an opportunity to submit a response. Usually it's within 30 days that you receive the notice, or 33 days if you've received it by mail. But keep in mind that they've extended flexibility, so they've added an additional 60 days to respond to these. And so this is where you're really going to have to make sure that you get personal legal advice to be able to determine whether this is something that you can turn around. It's essential at this point to get legal advice, because sometimes the issues are more complex than you can handle. There's sometimes you may feel like this is hopeless, and an attorney can easily identify where the officer may be making a mistake of law, or where the attorney can actually present law to, or a legal argument to the officer that can convince them that you are eligible for the immigration benefit. So the bottom line here is, if you receive a notice of intent to deny, don't panic yet. It is not an official denial. It is your last chance to prove that you are indeed eligible for this. Now, for example, where you will see a notice of intent to deny is where you have not proven that you're eligible. So in marriage-based cases, oftentimes individuals who have gone through the interview process will get this letter, this notice, because after the interview, after the evidence has been submitted trying to prove the bona fides of the marriage, the officer still may not be convinced. Now, this is something I help clients with. If you should ever get a notice of intent to deny, you should definitely schedule a consultation, and we can talk about this. This is a very fact-based situation. In some cases, for example, if I review the notice of intent to deny, I may very well see that there may be no way around it, but in other cases there may be a way around it. And so it really comes down to what happened in your particular case to determine whether it is something that can be turned around to get an approval instead of a denial. How can I apply for a business visa? So a business visa is very vague here, because there are different types of visas. And so, Christine Sugram, that's where you'll have to schedule a consultation. I need to figure out what your goals are. Are you running a business now? Do you want to start a business? Do you want permanent residence, or do you want a temporary visa? So I would really need to figure out your goals before I can tell you, because there are multiple types, different types of visas that have to do with business or employment. So let me remind you that I'm also here to answer your U.S. immigration related questions. So put the questions in the comments as long as I'm here. I just came on to tell you about this bit. Oftentimes I will get a panicked call from someone who is now seeking legal advice, and they would say, I got a denial. And I at that point, I can tell them the notice of intent to deny is not it is not a final denial. It is basically a warning to say that you're about to be denied, but we want to give you another chance. So, Oma, I got an RFE, my medical was expired. So, yeah, now I don't know your situation. I wouldn't know what happened with the medical. Right now, they've extended it for 4 years validity, and they have also extended the period of time to submit it after you've done the medical. But in your case, I wouldn't know whether that was correct. If I were the attorney on the record, you want to verify that information before doing another medical. So it depends. But Oma, you know your case, or if you don't, schedule a consultation and we can talk. Now, let's talk about the RFE. So the RFE is a request for evidence, and it could be for anything. It could be something simple like a letter to you saying you left out your marriage certificate, we didn't receive it, please send it. Or it could be more complex, and it can involve more complex legal issues. So whenever it comes on to the request for evidence, whenever it comes on to the notice of intent to deny, you need to get legal advice, get an attorney involved. I am a U.S. immigration attorney, and I do help clients with these types of situations. Now, let me tell you another way. While sometimes request for evidence and the notice of intent to deny it may be something that cannot be avoided, and a U.S. immigration attorney can make it less likely to happen, just because the U.S. immigration attorney, as an U.S. immigration attorney, I'm experienced and I have gone through these processes multiple times. I know what to expect, and I know what to avoid. But an individual applying on their own may not know how to avoid certain pitfalls, and that's where this can increase the likelihood of a request for evidence or even a notice of intent to deny. So I sent RFE response, but I am waiting for another mail from them to determine my case status and decision. Okay, so Oma, best of luck. If you need legal advice, you can always schedule a consultation. I filed my I-485, but it's been 15 days and they still don't show received. It's weird. So it ebbs and flows. So there are times when they're backed up, and it may take a minute for them to send you the receipt notice. I know it was really bad during the initial weeks of the COVID. That has eased up now. I'm noticing receipt notices anywhere from a week to 4 weeks. But if you go ahead and check on your case, call the USCIS. If it's been 15 days, is not a long time to wait. But if you do get worried, you could call and go ahead and schedule. Is USCIS wait times longer? Because my husband did his fingerprints, but we are waiting on the next step. So yes, definitely things are much longer. I'm petitioning for my husband. Is it a bad look for him to get a work visa while waiting? Shade, it could be. If it's a temporary employment-based visa and your husband is being petitioned at the same time, then it could mean that he has immigrant intent. That means he has the intent to come to live in the United States permanently. And so at that point, they may deny it. However, I don't know your situation. I'm not your attorney. And so I would have to go ahead and speak with you in a consultation to determine whether that is a good idea, or speak with the employer who is applying for your spouse. How do I go about filing for N400 and how long does it take? So while you can do it by paper, you can do it electronically. I file all my clients' cases electronically, and I'm finding that my clients' cases are taking anywhere from 2 months to 6 months right now. But keep in mind that the results that my clients are getting does not mean that that will be the case for you if I represent you through the process. Does USCIS C14 work visa come with an automatic SSN? If you have put on your application that you would like them to issue an SSN, then yes. But if you didn't state that, then you may have to apply for it separately. Great questions. Keep putting the questions in the comments while I'm here. I will go ahead and answer your questions. I want you to know that I'm also going to be hopping on over to Instagram, where I will be continuing the live. So if you have joined late and you really have your immigration questions that you want to ask, go ahead and hop on to Instagram. It's The Immigration Attorney on Instagram. We can continue the conversation here, but by all means, keep putting your questions in the comments. As long as I'm here, I will answer. What would be considered good proof to prove your relationship is real besides photos? So it's going to vary depending on the couple, but you have, and not every single one is required. It really depends on how you're living as a married couple. But if you are apart, so if you're going through consular processing, then it's going to be, it depends, but it's going to be, a joint property. If you're sharing a joint bank account, it's going to be exchanged money that you have been doing. It's going to be phone records, WhatsApp records. It's going to be social media postings. It's going to be affidavits from friends and family. So those are examples if you're apart and you're going through consular processing, you're not living together yet. But if you're going through the adjustment of status process, that means you're together in the United States. It's going to include joint lease if you're added on to if you share benefits like insurance, life insurance, automobile insurance, if you own property together. If you have a joint account together, that's going to also be good evidence to show. Tinichi, you're welcome, and thanks so much for the roses. I appreciate it. Thanks for the love. So Jazzy Jazz, okay, so you're going through adjustment of status. Can you be Jamaican and file for your own stay on a visiting visa? So if you're on a visitor's visa, you have to qualify in some way by having some link to the United States, whether it's through an employer, whether it's through family members, whether it's through investment, whether it's through, and this is a qualifying investment, whether it is through humanitarian means, but you wouldn't be able to file on your own. Just jump from a visitor's visa to permanent residence. All right, so I'm going to head on over to Instagram. Right now, I'm The Immigration Attorney on Instagram. You can join me there, where I will continue to answer questions like these. Now, remember, the takeaway here is the notice of intent to deny is not a denial yet. There is still a chance to turn things around, but that's where you should get a legal representation. And that is what I do for my clients. You can always go ahead and schedule a consultation by going into the link in my bio. When you go there, you will see a button, schedule your own appointment, or you can go to the website, you can call, and there's also the phone number is all over my pictures. Thanks so much, J876. Thanks. And Cubans1, thanks so much for the love. I appreciate it. Now I'm heading over to Instagram. I will be back. If you can't join me on Instagram tomorrow, I will be back at 9 p.m. Eastern time, around 9 p.m. Eastern time, where I will continue to answer your questions and bring topics like this to talk to you about. House 53, thanks so much for the follow. I appreciate it. So share this video, share the live with the other individuals that you know needs immigration information, because that's what I do here, is I share information, but keep in mind it's not personal legal advice. You have to schedule one with me by calling the number, by going to the link in my bio and scheduling your own appointment to be able to get legal advice. But it is worth it, right? What I'm saying here is don't gamble with your future in the United States by trying to do it yourself, right? This is not a process where you should be doing it by yourself. And it's a very deceiving process because you may think it's simple and it really isn't. All right, have a good night. I will see you tomorrow at around 9 p.m. Eastern time, where we can continue this conversation. You can also hop on over to Instagram